Thank you very much. Good morning, ladies and gentlemen. I've not really prepared a speech, and this is all the fault of Mark Sobel because we've been discussing quite late yesterday evening. But I'd like to make a few remarks maybe on transatlantic issues and what we discussed yesterday. We plan to issue a joint statement probably later today. That will tell you everything you're very eager to know about what we discussed. Maybe start with recalling everybody a simple reality. The US and the EU together account for 80% of financial transactions in the world. So that means what we decide together, the way we interact matters to the world at large. And also we will not account for 80% of financial transactions in the world forever. What we see is increasing competition from elsewhere, in particular Asia. And of course, the more we will be able to devise common rules, or at least compatible rules, the more we will be able to design what Michel Barnier called at the beginning of his tenure a genuine transatlantic financial market. And the more we are likely to keep this position of predominance and resist the challenge that other places in the world put to us. So this is certainly the spirit with which the European Commission takes the transatlantic discussions. I think it's fair to say that, as Kay just mentioned, I mean, never forget we're in a better place than we were. And when I say we, I mean globally, the EU and the US. We both made a huge effort, first in devising. I think it's clear that EU and US have been key in designing the G20 agenda. I think also experience shows that when we agree, it works and we move forward, and when we disagree, the process is stalled. So it is extremely important that we dialogue. It is extremely important that we better understand each other, because to be absolutely frank with you, most of the time we share the same preoccupations, we share the same concerns, we identify the same problem. It is simply that we have different ways of addressing it. We have different culture. That's arguably a bit more complicated here, because you have to put together the Anglo-Saxon culture, the continental culture, if it does exist, and design a system that is usually complicated because, to say the least, we don't trust very much each other, but I'll come to that in a moment. When you take a closer look to the US reality, it is complex as well, because of the federal system, because of the agencies. So we all have our own idiosyncrasies and complexities, but we have to come over that in order to get a system which doesn't need to be identical, but what we need to do and what we're trying to achieve through this dialogue is to get a better understanding of each other's systems, to interact so that the concerns of one party can be fed into the process of the other, and in the end of the day, have systems that we mutually trust and supervisors that we mutually trust. And this is what is important, and this is what is key in minimizing regulatory overlaps and double supervision systems. It will be a long process. It doesn't happen like this. Trust is something that builds in very slowly and can be destroyed very quickly. So if you look at what happened last, say, 2 years with these glasses, I think it's almost unexpected, the amount of progress that the EU and the US achieved together. And of course, I don't want to go on the territory of the second panel. I think we both believe we should step up our cooperation. We simply have different ways of envisaging how this should be done. The way we see it, I think reflects very much what Kay said. We believe that in an ideal world we should move towards global standards that can be readily adopted by the various jurisdictions, and a dispute settlement system that allows to fix problems where they arrive, on something that is binding on the various parties. I'm not so sure the US necessarily disagree with this. It will be for Mark to tell. But in any case, I think there's something that we can agree on, that if it happens, it will happen in a long time. These things take time. And it's difficult for any state or a grouping of states to abandon a piece of sovereignty. And we see it every day in Europe, and it's the same at the international level. So this is why it matters. The second thing is our focus, very much like our focus in Europe actually, is now on implementation. The regulatory work that has been done by the co-legislators over the last 5 years is just incredible. I think it amounts to 41 pieces of legislation. It's not that we're proud of that. I mean, we would have loved to do less for many reasons, but it had to be done. And this puts on us, and this puts on the market, and this puts on the supervisors a huge responsibility and a huge challenge, which is the challenge of implementation. Kay talked about level 2. She's absolutely right. Level 2 matters for many reasons. One of the reasons is that a lot of difficult issues that the co-legislators could not agree on in the level 1, they kicked into level 2. Actually, yesterday, I made a little calculation how many level 2 acts the Commission proposed originally and how many level 2 acts we end up with. It tripled. And frankly, if I may say, okay, this is bad practice. This is bad practice because the problems are still there and they will still have to be decided. And the result is that the Commission is faced now with having to produce around 400 secondary legislations within 6 months. And with various requirements that we should consult and reconsult and consult again, and this is simply impossible. This is not good practice. We will do it. We have to do it. I'm not so sure it's better for the democratic accountability either, because as you know, in level 2, we put our proposal and you can only veto it as co-legislator, which is not necessarily the best way to do it. So maybe based on this experience, we should collectively think the way we will work together for the next mandate. And this is a message I would certainly like to address to the Council as well, because everybody is guilty in this thing. But implementation is going to be a problem. And implementation means level 2, but it also means implementation on the ground by our supervisory authorities. And given the amount of legislation that we've been producing here in the US, I have little doubt that we will spot problems at implementation level that escaped our attention when we designed the level 1 or level 2, actually. We will spot problem within each piece of legislation, and even more probably, we will spot problem at the border, at the interaction between pieces of. Kay mentioned EMIR and MiFID. There are key interactions between these two texts. I think, that the way they were initially proposed by the Commission, the interaction was right, and the two texts would seamlessly work together. I hope, and I'm not so sure, that this will be the case now as a result of the legislative process. I mean, things moved, compromises were done, and some of them may result into either overlap or underlaps, and we will have to be very careful about that and be ready to work with the co-legislators to provide for quick fixes whenever it is necessary. And the last challenge of implementation is, of course, international consistency. As The EU has decided to have a system that is based on equivalence. So we are an open area in which you can trade from the outside, provided we are confident that you're subjected to essentially as good rules as ours, that do not need to be identical, but we need to be confident they're as protective as ours. With different words, the US system is based on the same philosophy, and of course none of us wants to compromise on the level of protection afforded by our national or respective legislations. This in a context where we're both aware that we need to give our market operators an as easy life as possible while being subjected to efficient and effective supervision. So what we did yesterday was to review the key sectors in which issues of international implementation arise. I think it's fair to say, when you were right in saying progress are slow. Well, I'm not so sure they're so slow. For the last year, I think we made a lot of progress with the US. It was a bumpy ride, yes. We had our difficult times. I remember the war of press releases with Gary Gensler. But okay, all in all, we made quite a lot of progress. So the key issues were insurance. So in insurance, I think we have a common understanding that we should move rather sooner than later to a covered agreement. We have our processes. The US have their processes. They need to be respected. We need, in particular, as you know, to obtain a mandate for negotiations. But the common understanding is moving forward in a very satisfactory way, and we are expecting good outcomes. You mentioned it, and of course, this is the hot topic of the moment, derivatives. On derivatives as well, we have a very intense, very productive, and fruitful dialogue. We have our rules, they have their rules, and we need to find a way to make them interact in an as burdenless way as possible for our operators, so that the US operator can market and work in Europe, and our operators can work in the US. This is not necessarily easy, but this is doable. It involves a number of highly technical issues to be solved. This is what we discussed, and this is what we are doing. And as Mr. Barnier said when he was in Washington, we are confident, because we have deadlines in this exercise, that we can reach a good outcome by the deadlines. Let's not be mistaken. The issue here is market fragmentation. I mean, if we're serious, and at least we're serious with what I said at the beginning, that we want a seamless transatlantic market for financial services, we should at least avoid fragmentation among ourselves. So this is what we're trying to do. Again, it's complicated, but on key issues like margin requirements, we are making good progress in reaching a common understanding as provided for in the path forward.